question and answer. The first question comes from Lisbon Bosire. He asked, strategic litigation has been used as a tool to undermine development as other revisions argue. What can be done to ensure that the litigation is devoid of interest, such as state targeting and utility, other non-friendly countries?
Such as? Yes. Can you repeat the question?
Strategic litigation has been used as to undermine development, as other revisionists argue. What can be done to ensure litigation is devoid of interest, such as state targeting and hostility from other non-friendly countries? Any advice?
Of course, as we all know, that law can also be an instrument of reform in much the same way that it can be an instrument for maintenance of status quo. What I know for certain is that the financing of this strategic litigation, for example, public interest litigation, there are always other interests, civil society interests, social movement interests, who are pursuing a particular agenda, either against the government or against these institutions. That is not inherently a bad thing, because we are always looking for critical alliances from forces that can enable us to achieve that egalitarian emancipation that we are seeking. Now, how do you dethrone some of these interests? I actually do not know, but I think if those interests are for advancement of social justice, they are supportable. If they are for any other interest, such as sabotage, business rivalry, that can be dealt with at another forum. I think so. But I think the question of critical alliances is very, very important. How else would we fight, for example, the injustices of transnational companies, for example, the Chinese company that violated people during their development projects, road construction projects, or mining companies that violate people in the coast in Lamu, for example? How else would you challenge these institutions if you do not get support from those other interests? So I think those other interests are inherently good things. Where whatever agenda or vendetta they may be pursuing, that may not necessarily be a legal question. Any other question?
The following question from Aaron Ayodo. Aaron asks, on the flip side, are there instances where the World Bank or IMF has sued a developing country for getting their World Bank or IMF funding?
I'm not aware of any case where the World Bank has sued any country for any reason. But probably the question would be, are there some instances when a country has sued the World Bank for the ramifications or the effects of structural adjustment programs? Now, as I said, this is the reason why the strategic litigation in this area is very, very important. Now, the IFC was only recently sued in 2019. That's when the success came. That is when the absolute immunity, the totalizing jurisprudence of absolute immunity was actually ruptured by the Supreme Court jurisdiction, by the Supreme Court decision. Now, there's therefore reason for us to explore these new areas for litigation, whether it's public interest litigation, whether it's pro bono services. I mean, it would be very interesting to see a Kenyan lawyer argue before the Washington, D.C. court on behalf of residents of UAE, for example, who have been violated by a World Bank funded project, a road construction project that has polluted the environment, has downgraded the soil fertility in that area. Crucially very interesting, but I'm not aware of any case where the World Bank has sued any state.
Another question comes from Stephen Kukagio. Choice of the flame. How does one establish action. Um, how does one establish causality between the WP and the harm complained about? In all countries where these institutions work in, the owner and implementer of the project is the government of the state. The state designs the programs and the IFOs finance those programs.
Now, that is a very, very interesting question. That's a very, very interesting question. And I think that's where the cracks lie. How does one establish causality between the World Bank funded project or the World Bank and the harm itself? Now, there is always a veil, what we call a veil of ignorance, even among World Bank and even government bureaucrats. The fallacy, the fallacy that the government designs these projects. Now, of course, the World Bank came up with this policy of ownership, accountability, that the government owns this project, they design this project with participation of civil society and other stakeholders. The real stakeholders, the people who control the levers, are actually the World Bank technocrats and bureaucrats. They can change those government programs, however designed. This is what happens. For example, IMF surveillance mechanism procedure that always visits countries and they look at the broader or macroeconomic policies over a period of time. The government make the recommendation. The real people who design those programs, who have got a say, the final say, supreme say, are actually the IMF and World Bank technocrats. Now, that question of establishing causality was actually raised in the IFC case. The question was that the harm actually occurred in India. All these complaints, like the real actual harm, the dredging, the pollution of the water, was an act of the Gujarat company that was implementing this project. Now, the financing came from the IMF, that was the argument. Now, establishing causality at times is not all that interactional, in my view. The fact that the action of the World Bank must cause or must be shown to have caused that direct harm. Now, causalities at times are indiscernible, in that the harm inheres in the action and the conduct. For example, when approving a project, a government program, and the World Bank insists on a particular measure, it is that measure that is going to have a causal link that may not have a direct and discernible or visible causal link, but it has an indirect impact on the people or on the harm that the people suffer. Now, that is a legal question. The causality is always a legal question. Establishing the nexus between the harm suffered and the institution of the World Bank. It's a legal challenge. But yes, the argument here is that the World Bank always is on the driver's seat, or the IMF are always in the driver's seat whenever they are recommending these macro policies for countries. Therefore, causality can be established in the sense that the real harm that the people suffer are traceable to these structural measures and policies of these institutions. That is the argument that I would establish. Any other question?
Washington.
Yes, Doc.
I can see some questions here. I can just read them on myself. How independent are these adjudicatory panels? There's an anonymous who has asked. They are not independent. They are only independent from far, yet they are far from independent. Not independent at all. If an institution has got to be independent, there is no way you can claw back the powers by stating that whether to investigate by the inspection panel is actually subject of the board's approval. There is no independence there. Dorothy Angote excited about the dethroning of the absolute immunity concept, having dealt, that's not a question. But thank you so much, Dorothy, for the comment. Any other questions here? Washington, can you read them?
Yes, Doc. What is the financial interest of the US in the World Bank not sufficient nexus? Did this arise in the US Supreme Court? I mean, the World Bank is spending US money to finance these developments? That's the next frontier.
Why is the financial interest of the US in the World Bank not sufficient nexus? I wish that Stephen is asking about the fact of the IFC case. Now, the question of sufficient nexus is this. That's what has been established in IFC, is that the harm suffered or the conduct that has caused the harm must have a sufficient nexus to the US. So the argument in the IFC, before the IFC, was that the IFC's failure to ensure a proper design, implementation, and so forth was actually the cause of the harm on the lives, property, and the environment that the people incur. That failure, and that failure in the approval process happened in the US. That's what they call the nexus, or the substantial link. Is that the conduct itself is what the case calls the gravamen, or the core of the case. Like, what is it that gives rise to this cause of action? Whatever gives rise to the core cause of action must have arisen in the United States. And in this case, the argument was that the failure itself happened in the United States. As I said, in the case of Rodriguez versus Pan American Health Organization, the approval of the salaries of the Cuban doctors happened in the United States, and you can there see the substantial link. The complaint was that the Cuban government had subjected these doctors to slave labor, the same way that they do here in Kenya. They are paid a lot of money, but part of that money does not go into them. It does not go directly to them. It goes first to the government, then the government pays them. Now, the real cause, like the gravamen of their case, was facilitated by conduct of the defendant that is domiciled in the US. Okay, so that's how one can establish a sufficient link or nexus.
What does an ordinary self-impacted negatively by a big one bank funded project do when the government signs a basic agreements? No litigation can correct a bad contract.
Funded project do when? What is the question? What can?
I repeat, what does an ordinary citizen impacted negatively by a big World Bank funded project do when the government signs oppressive agreements? No litigation can correct a bad contract.
Now, this is a question that I think needs deeper reflection. We recall that at the time the government was entering into a new lending agreement with the IMF, there was a lot of hue and cry. But that transactional nature was going on. Now, in my view, I think one could challenge that sovereign decision between the government and IMF at the time that is about to happen. If there can be sufficient evidence that some of those austerity measures, because nobody actually knows, nobody even knows the terms of those agreements that the government enters into. Yet, IMF and the World Bank always claim, this fictitious claim that these are participatory processes. Who knows who participates in the negotiation between the Treasury and IMF? Nobody knows. Now, but there is evidence out there, absolute evidence, empirical evidence over the years, including an admission of the World Bank, that some of these austerity measures or conditionalities of these institutions are actually human rights retrogressive. Now, that is sufficient evidence that can be brought before the court for the enforcement of fundamental rights of individuals. So I urge lawyers that this is probably one area where poor people can be protected when we suspect, or there is genuine apprehension, that some of the agreements between the government of Kenya and the World Bank or IMF may have some potential deleterious effects in the future, going by the records. Yeah, there's a question here. Has there been any backlash against these institutions? Who may sue them? Have the suits which have been filed resulted in any positive change? That that is a question that needs empirical research. I haven't done it. But once, because if you read very keenly, the comments that are coming out in the scholarship suggest that more and more people are resisting these institutions, whether through strategic litigation before the court or through their own independent panels. There is going to be some level of change, or some level of reform, internal reform, because these institutions are not impervious to change. They're not impervious or resistant to the hue and cry and agitation of the people. In some way or another, they always reform. And that's why we have, the World Bank now have what we call the participatory approach to development financing. The people must participate, communities must be involved. That's when the government must decide those projects. So, however small or incremental the changes are, there is going to be some positive change on the ground. But there has not been so many litigation against the World Bank or IMF. We should urge our Kenyan lawyers to take up this role. Any other question?
Just the final question.
Yes.
From Peter Toronto. Says, I'm doubtful internal planning for committees set up to scrutinize WBG and IMF programs will achieve much because it is akin to marking one's homework. Beyond the process is to be deployed to capital-intensive projects which are the most likely areas of corruption in developing countries for the elite. The IFIs are compelled to spend a lot, otherwise contributing countries will decrease donations to these organizations.
It's true, I agree with him. The World Bank inspection panel mechanism is a facade of accountability. It cannot bring real accountability of the World Bank to international norms and standards. Nobody can enforce human rights before the World Bank inspection panels. There is really no real accountability before the World Bank inspection panels. That is all I can say.
Thank you, Doc. Massive says is not my comment on financial inclusion above. Massive Blue, excellent presentation. This global discrimination is also evident in the application. The UN on
I didn't quite clearly get your question. I don't know whether we still have you, Washington.
yes, Doc. This is a comment. He says this global is also evident in the wholesale application of it, such as the VAT recommendations on anti-money laundering and the fuel for countries to the detriment of other SDGs such as finance with specific reference to financial return. Then, but as the twin goals of financial inclusion critical importance, a useful talk in future CPD sessions. Thank you, Mercy, for your comment. So I think at this juncture, Dr. thank you also. We'll end the webinar. The slides will be available in the sessions.
Yes, I will send the slides.
Thank you very much.
Thank you so much too.